Basically, this motion to dismiss seeks the premature dismissal before any hearing on the merits, before any witnesses have been heard. It seeks the dismissal of the suit and the preclusion of the plaintiff from ever suing on the same or similar basis again. Chances of that happening? I will eat my torn Tommy John underwear. How's that? So federal judge William O. Bertelsmann actually granted Washington Post's motion to dismiss of Nicholas Sandmann's defamation lawsuit. Obviously, I have to do a follow-up breakdown of this judgment, given the fact that a while back I did a breakdown of the Washington Post's motion to dismiss, and I did not think it had any reasonable chance of success at the preliminary stage of a dismissal before evidence was made. Now, obviously, my initial prediction was wrong, with the caveat that Sandmann's attorneys are going to appeal the dismissal of the suit, so we'll see what happens at the Court of Appeal, and by analysis of Judge Bertelsmann's granting of the Washington Post dismissal of suit is not going to be an attempt to sort of correct or justify my initial prediction. I rewatched my original video on this subject, and I pretty much stand by everything I said in that video because I believe it to be true, and I believe it still to be true. And reading Judge Bertelsmann's decision, in as much as the Washington Post's motion to dismiss read like a defense, Judge Bertelsmann's granting of the Washington Post's motion to dismiss reads like a judgment on the merits. Bearing in mind that this is a long process and it's not the end of the game right now, but again, it's not a question of being right or wrong. I don't mind being wrong. I've been wrong in the past and I'll be wrong again in the future. The only thing is that you want to make sure that you have a reasonably educated opinion at the time, and like I always say, once you leave something in the hands of a judge, you can never predict the outcome. Alright, we do not once again need to do a detailed breakdown of the timeline of events, the facts. I take for granted that everyone watching this video already knows the facts. If you do not already know the facts, go watch my 2 previous videos on the subject, watch other people's videos on the subject to get an understanding of the facts. At this point, I would feel comfortable in saying that if someone does not know what is going on in this situation, they have in fact been living under a rock in a cave with no electricity and no neighbors to relate to them what is going on in the outside world. The decision. At page 4 of the decision, the judge sets out what are going to be the parameters of his judgment. The court must now determine whether Sandmann's allegations state a viable claim for relief. These are purely questions of law that bear no relation to the degree of public interest in the underlying events or the political motivations that some have attributed to them. And this is an important statement setting out the framework of the judgment on the Washington Post's motion to dismiss. The judge is saying that these are pure matters of law. Hence, the judge is in a position to adjudicate on them at the early stages of a motion to dismiss before evidence has in fact been adduced. So the judge looks at the statement of claim, the judge looks at the motion to dismiss, and the judge says whether or not, in law, as a pure question of law, there is a viable claim to be submitted to a trial by jury. Whether or not the judgment in fact purely adjudicates on matters of law is something that we'll discuss, but that is the framework within which the judge is supposed to render his decision. At page 5, the judge writes as follows. The court need not, however, quote, accept the plaintiff's legal conclusions or unwarranted factual inferences as true. To state a valid claim, a complaint must contain direct or inferential allegations respecting all the material elements under some viable legal theory. Accordingly, in ruling on the Post's motion, the court may consider the 7 articles, the tweets, and the 2 YouTube videos because these materials are either referenced in or attached to the complaint, and Sandmann relies on them in support of his defamation claim. The court excludes all of the materials attached to the parties' briefs. And so what the judge is saying right now is that he is going to base his decision on the Washington Post's motion to dismiss solely on the articles, the tweets, and the YouTube videos that are referenced in Nicholas Sandmann's statement of claim. There's not going to be any testimonial evidence from Nicholas Sandmann, from Nathan Phillips, from Washington Post journalists. The judge is just going to rely on the 7 articles, the 2 tweets, and the YouTube videos in order to determine whether or not Nicholas Sandmann has made sufficient allegations to justify his claim in law. At page 6, the judge goes on to state the criteria for establishing defamation under Kentucky law. In Kentucky, a cognizable claim for defamation requires A. A false and defamatory statement concerning another. B. An unprivileged publication to a third party. C. Fault amounting at least to negligence on the part of the publisher. And D. Either actionability of the statement irrespective of special harm or the existence of special harm caused by the publication. Now, ultimately, the judge is going to grant the Washington Post's motion to dismiss on the basis that the Washington Post's articles are not about Nicholas Sandmann, in that they don't specifically identify him, they don't name him by name, at least in some of the articles, and they're referring to a group of people, not specifically Sandmann, such that these statements are not defamatory about Sandmann per se because they do not identify Sandmann. Another basis for granting the Washington Post motion to dismiss are going to be that these statements in and of themselves are not defamatory because they are either opinion, susceptible of interpretation, and are not factually incorrect statements about Nicholas Sandmann. And at the end of the judgment, there's a table indicating all of these statements and the reason for which the judge concluded that they were not defamatory. Page 7. The first element of a defamation claim requires that the challenge statement be about or concerning the plaintiff. Generally, the plaintiff need not be specifically identified in the defamatory matter itself so long as it was so reasonably understood by plaintiff's friends and acquaintances familiar with the incident. And an important legal criteria at page 8 sets out the fact that if a statement is made against a group of individuals without specifically targeting or naming any one member of that group, no one member of that group can lay a claim for defamation. Meaning that if the statement just says a group of people did X, Y, and Z without specifically naming any one individual of that group or allowing them to be so reasonably identified, no individual member of that group can lay a valid claim for defamation. As a principle of law, it is understood. As it applies as a matter of fact to every particular case seems to be a matter of fact for that particular case that ought to be submitted to the appreciation of the jury, but at least as a matter of pure law, a statement made to an aggregate group without specifically identifying any one individual or causing them to be so reasonably identified cannot justify a claim for defamation of any one member of that particular group. Another interesting element in law is at the end of page 9 where the judge says that only assertions of fact can be defamatory. Opinions themselves cannot justify a claim for defamation. Thus, quote, the falsity requirement is met only if the statement in question makes an assertion of fact, that is, an assertion that is capable of being proved objectively incorrect. Therefore, apparently, statements of opinion cannot serve as the basis for an action in defamation because they cannot be proven demonstrably false. They are simply a matter of opinion. How this general principle of law might apply to specific situations is very interesting. Saying something along the lines of, I believe that person is a criminal, as phrased, seems to be a matter of opinion. Does that mean it cannot serve as the basis for a defamation lawsuit? I only said I believed that person was a criminal. I did not say that that person was, in fact, a criminal. Page 10. Lastly, to satisfy the first element of a defamation claim, the language in question must be both false and defamatory. A statement that is false but not defamatory is not actionable. A statement that is true is not actionable even if defamatory. And this goes back to one of the underlying principles of a defense to defamation. The truthfulness of the statement is an absolute defense to an action in defamation. But the first half of this statement is one that mixes general principles of law with application to specific facts. An action in defamation requires a claim that is both false and defamatory. And it seems, at the very least to me, that the falseness of a statement and its defamatory impact on an individual is a question of evidence. Evidence which has not yet been adduced in the context of the Washington Post's motion to dismiss. But the judge does address this in the following paragraphs, so let's get there. Kentucky common law treats a broad class of written defamatory statements as actionable per se. But in order for a defendant's written statement to be actionable per se, justifying a recovery without averments of special damages, it must be more than annoying, offensive, or embarrassing. The words must tend to expose the plaintiff to public hatred, ridicule, contempt, or disgrace, or to induce an evil opinion of him in the minds of right-thinking people. And we're going to get back to this particular statement and how it applies to the judge's assessment of the Washington Post's articles. At page 14, the judge writes as follows. An individual member not specifically imputed or designated cannot maintain an action. Sandmann is not specifically mentioned in the article, therefore, because the words used contain no reflection upon any particular individual, no averment can make them defamatory. And this is where I ask questions about how the general principles of law are being infused with matters of fact and evidence. As we saw earlier in this very judgment, these statements need not specifically refer to any one individual. It need only relate to the allegedly defamed individual if it was so reasonably understood by plaintiff's friends and acquaintances familiar with the incident. So I do ask myself how the judge came to the conclusion to grant the Washington Post motion to dismiss on the basis that it does not specifically name Nicholas Sandmann as the individual in the article, without getting into the evidentiary issues as to whether or not it was reasonably understood by plaintiff's friends and acquaintances familiar with the situation that they were in fact talking about the plaintiff. Okay, fine, Nicholas Sandmann wasn't specifically named in the articles. The question then becomes whether or not it was reasonably understood by friends and acquaintances or people familiar with the situation who was being described in that particular article. But these seem to be questions of law mixed with appreciation of facts and evidence that have not yet been adduced at the stage of a motion to dismiss. And I am not convinced that terms like swarmed, physicality, taunting, etc. are loose hyperbole that are not susceptible of being proven true or false. It seems to me that it is very easy to prove whether or not someone was in fact swarmed, whether or not people were in fact engaging in physicality, whether or not people were in fact taunting. It's not because terms are descriptive that they cannot be proven true or false. All the more so in the absence of having adduced any evidence as to whether or not there was in fact physicality, whether or not there was in fact taunting. And again, whether or not the judge or the jury came to this very same conclusion after all of the evidence had been adduced and appreciated is one thing. To come to the conclusion conclusion at a preliminary stage seems premature to me. And reading further on into the judgment, it seems that the judge is in fact appreciating evidence that has yet to be adduced. Sandmann admits that he was standing in silence in front of Phillips in the center of a confusing confrontation between the students and the indigenous peoples group. Sandmann's intent, he avers, was to defuse the situation by remaining motionless and calm. Phillips, however, interpreted Sandmann's action, or lack thereof, as blocking him and not allowing him to retreat. Phillips has not yet testified as a witness. The judge is coming to Nathan Phillips' interpretation of the events based on what was relayed in the article that is at issue. It is potentially a question of fact as to whether or not Phillips in fact felt what he said he felt in the article. Phillips can in fact be contradicted on the statements he made to the Washington Post as to whether or not they were in fact true. Nathan Phillips' initial statement can be tested in court. The veracity of that statement can be tested in court. The legitimacy of what he purports to have felt at the time can be tested in court. In granting the Washington Post motion to dismiss, the judge is coming to conclusion as to Nathan Phillips' interpretation of what happened in the absence of Nathan Phillips' actual testimony as a witness. This may be a legitimate conclusion for the judge or jury to come to after everyone has testified, but it seems grossly premature to come to this conclusion before any evidence has been adduced, before Nicholas Sandmann has had his day in court, and his day in court means his opportunity to make evidence to support his claim. And the court comes to the conclusion that the statement that Nathan Phillips felt blocked by Nicholas Sandmann is a matter of opinion and therefore not actionable. And in support of this conclusion, to justify the motion to dismiss, the court cites another decision, and I'll read from that at page 19. The father testified that his foot simply gave way, causing him to fall, and that the nurse's statement that he blocked the police car was defamatory. The court held, however, that the statement was pure opinion because all the underlying facts on which the nurse based the block statement were disclosed. And so here we have the judge citing another authority to the effect that matters of pure opinion are not actionable. But the subtle yet major distinction is that the judge is citing from a case where testimony was adduced. The judge is citing from an authority that actually went to evidence. The case that the judge is citing in order to grant the Washington Post motion to dismiss at a stage where no evidence has been adduced and no testimony heard, itself is a case where testimony was heard. Therefore, the parties had had their day in court, had had a chance to adduce all the evidence they wanted to adduce, and the court came to the conclusion that the statement was one of opinion and not of fact, therefore not possibly defamatory. That is materially different from the situation at hand where no evidence has been adduced and no testimony has been heard to determine whether or not the statements were fact or opinion and whether or not they could in fact be proven false. And reading this decision, I don't know which authorities that the judge is relying on actually went to trial, actually had evidence adduced, versus which are authorities where a motion to dismiss was granted at a preliminary stage. And it seems that it would be problematic if we are applying authorities that went to trial to grant a motion to dismiss prior to evidence being heard, because the situation is totally different once the parties have had an opportunity to adduce all the evidence they think is necessary to justify the claim. Chili peppers. I see. They smell good. Oh, and Barney the Vlawg dog is here. Okay, I will be down in 5 minutes. And take Barney, he makes too much noise.
Eat it, I want to see you eat it.
A hot chili pepper is not something that someone should be eating at 8 o'clock on a Saturday morning before having eaten breakfast. Oh my god, that's spicy. Okay. Okay, we'll be back. At page 21, the judge writes something which I think is very problematic in light of what the judge says a page later. And while unfortunate, it is further irrelevant that Sandmann was scorned on social media. That is extrinsic evidence of context or circumstances outside the four corners of the article that renders the publication liable per quad. But then one page later, at page 22, citing Kentucky defamation law, the judge writes as follows. Instead, to be libelous per se, the defamatory words must be of such nature that courts can presume as a matter of law that they tend to degrade or disgrace the plaintiff, or hold him up to public hatred, contempt, or scorn. So on the one hand, you have the judge saying that it doesn't matter that Nicholas Sandmann was scorned on social media. It's unfortunate but irrelevant because it's outside the four corners of the article. But then on the other hand, state that under Kentucky law, defamation occurs when the defamatory words, and I'm quoting, tend to degrade or disgrace the plaintiff or hold him up to public hatred, contempt, or scorn. So I have great difficulty reconciling the judge's conclusion that it's irrelevant that Nicholas Sandmann was scorned on social media with the judge's statement that under Kentucky law, defamatory words are those which are susceptible of holding an individual up to public hatred, contempt, or scorn. At page 24, the judge concludes as follows. In sum, taking the ordinary natural meaning of the words in the four corners of the article, and when stripped of all innuendos and explanations, the gist or sting of the article would not tend to expose Sandmann to public hatred, ridicule, contempt, contempt, or disgrace, or to induce an evil opinion of him in the minds of right-thinking people. Again, on the one hand, we have the judge saying it's irrelevant that Sandmann was in fact the object of scorn on social media, while on the other hand saying it can't possibly be defamatory because it would not expose Sandmann to public ridicule, hatred, contempt, or scorn. These seem to be factually and legally mutually irreconcilable statements to come to in one and the same judgment, granting a motion to dismiss. And then at page 27, the judge distinguishes other articles which in fact name Nicholas Sandmann, all within the context of the same allegedly defamatory events. So you have some articles not specifically naming Nicholas Sandmann, other articles specifically naming Nicholas Sandmann, and then the argument is going to be, well, the first ones which didn't specifically name him are not defamatory because they don't specifically name him, while the other ones are not defamatory even though they do specifically name him? This is arguably one entire global context where even though Nicholas Sandmann is not named in one particular article, the fact that he is named in a subsequent article can allow reasonable people to identify the individual in previous articles, although not specifically named. But again, this is all evidentiary issues as to whether or not people in fact knew who the article was talking about, whether or not it was sufficiently clear based on the drafting, and certainly based on the fact that other articles specifically named the individual, in the context of whether or not it constitutes defamation. And so that is basically the gist of the judgment. Had this judgment been drafted after all the evidence had been adduced, that would be one thing. The fact that it is a judge at a preliminary stage on a motion to dismiss without having heard any testimony, without any evidence having actually been adduced, seems grossly premature. The fact that in one and the same judgment, the judge says things like, it doesn't matter that the individual was scorned on social media, yet under Kentucky law, the fact that it may lead someone to public hatred and scorn is relevant in determining whether or not words are defamatory, seems problematic. And one thing that seems grossly problematic in this entire 28-plus page judgment, not once is the fact that Nicholas Sandmann, a minor, addressed. It's almost as though no consideration whatsoever is given to the fact that the plaintiff in this dispute was, at all relevant times, a minor. There is no consideration given to the fact that there were articles that did in fact specifically name Nicholas Sandmann, and that you had the Washington Post specifically naming a minor in the context of their reporting. Given the context of this particular defamation lawsuit, that seems like a rather relevant omission in the context of granting a motion to dismiss before any evidence has been adduced, before everyone has had their day in court. Either way, it is not a question of me trying to save face or justify a prediction that did not come to fruition. It is just a question of understanding the facts so that you can come to a reasonable assessment, even if you happen to be wrong. And all that to say, if you like my content, be sure to like, share, subscribe, hit the notification bell. If you want to get one of these bad boy Vlawg dog shirts, the link is going to be below. Although 33 degrees on a sunny day, probably not the best day to wear a long sleeve shirt. Certainly not the best day to eat a hot chili pepper, but now I gotta go downstairs and eat some breakfast, which is going to incorporate some of these rooftop grown chili peppers. They're delicious, but spicy. Very spicy, as you can see, probably by the fact that I'm sweating like a pig and glistening in the heat of the midsummer sun, although it is only 9:17 in the morning and it's going to be a hot one today. And now you know your vlog. Peace out. Boom!